Our next witness is Christopher Nugent, who's co-chair of the Committee of Rights of Immigrants of the Section of Individual Rights and Responsibilities of the American Bar Association. Currently a senior pro bono counsel with the Community Services team of Holland and Knight. He works there specifically on immigration and public policy related cases. Mr. Nugent has over 20 years, is that correct, of experience in the field of immigration policy, recipient of numerous awards for his work. As a graduate of Sarah Lawrence University, holds a law degree from the City University of New York. Mr. Nugent, please go ahead, sir.
Thank you, Chairman Leahy, and thank you, Ranking Member Senator Sessions. It's a privilege and honor for me to appear before you. I'm appearing today at the request of Tommy Wells, Jr., who's the president of the American Bar Association, who was unable to attend the hearing. On behalf of the American Bar Association and its over 400,000 members, I would like to thank you for this exceptional opportunity to express the ABA's strong support for the Uniting American Families Act, which we hope will be integrated into any comprehensive immigration reform legislation. As the national voice of the legal profession, the ABA has a strong interest in ensuring that our immigration laws are both fair and effective, as well as we support efforts to combat legal discrimination on the basis of race, gender, ethnicity, religion, nationality, and sexual orientation. In the particular area of immigration, the ABA has adopted numerous policy recommendations concerning the administration of their system of legal immigration. Central among these recommendations is the core principle that the basis upon which foreign nationals should be able to seek permanent resident status should be both humane and equitable and should reflect the historic emphasis on both family unification and the economic and cultural interests of the United States. The ABA has also adopted numerous policy recommendations that oppose discrimination based on sexual orientation. We recognize the importance of providing committed gay and lesbian couples and their families with basic legal protections to help those families stay together. Family unification is an express and central goal of immigration policy in the United States and has been for more than 50 years. Currently, however, this principle fails the families of U.S. citizens and permanent residents whose same-sex partners are foreign nationals. U.S. policy does not allow foreign spouses and fiancés to immigrate and live with their U.S. partners. They allow foreign spouses and fiancés to immigrate and live with their U.S. partners, but it discriminates against gay and lesbian U.S. citizens and permanent residents by prohibiting them from sponsoring their partners for permanent residence in the U.S. As a result, as we've heard today, thousands of lesbian and gay binational couples and their children are being kept apart, driven abroad into virtual exile, or forced to live in fear of being separated, detained, or deported. This policy damages not only those families, but the United States society generally. According to the 2000 U.S. Census, there are 35,820 same-sex binational couples that live together in the United States. But due to current law and policy, they're prevented from immigrating into the United States, and many binational couples are forced to flee this country, depriving our nation of the economic, cultural, social, and other contributions that these individuals could have made here. Gay and lesbian partners are ineligible to access immigration opportunities, regardless of the depth of their love and the permanency of their commitment to one another. The Uniting American Families Act would not repeal or affect the Defense of Marriage Act in any material way. Rather, the Act simply seeks to provide a viable mechanism by which permanent partners of gay and lesbian U.S. citizens and permanent residents have access to valid immigration status on an equivalent basis to married straight couples. Moreover, gay and lesbian couples would be subject to exactly the same rigorous documentation criteria that are imposed upon heterosexual spouses, including productions of documents like joint leases, mortgage, joint bank accounts, family photos, and the like. The petitioning American partner would also be required to sign a binding affidavit of support, which is a contract that would obligate him or her to financially support the beneficiary for 10 years in the United States. In addition, the current penalties, which are 5 years imprisonment or a $250,000 fine for marriage fraud under the Immigration Nationality Act and the U.S. Code, would apply with equal force and vigor to gay and lesbian couples. Accordingly, for these reasons, the Act would not increase the opportunity for marriage fraud. In maintaining the current immigration restrictions that discriminate against same-sex couples, same-sex couples, the United States policy is in direct contradiction with many of our closest allies, including the United Kingdom, Australia, and Israel, which facilitate and embrace immigration benefits for same-sex partners. In conclusion, central to this nation's long history of immigration law and policy is to ensure that Americans and their loved ones are able to stay together in the United States. The current failure to recognize gay and lesbian permanent partnerships for immigration purposes is gratuitously cruel and unnecessary. Critical protections as provided in the Uniting American Families Act should be afforded and enacted to help gay and lesbian partners maintain their commitment to one another on an equal basis with different sex spouses. I thank you for your consideration of my testimony, and I look forward to your questions. Thank you, Chairman Leahy.
Thank you very much, Mr. Nugent, and thank you for the emphasis on the kind of scrutiny that would be given to anybody making this. As I understand, that's the same scrutiny as somebody who has a heterosexual couple, married couple, that would face the same kind of scrutiny. Is that correct?
Exactly. It would be the same exacting scrutiny and very rigorous documentation requirements and the threat of civil and criminal penalties. And as your bill, Chairman Leahy, states, it states that part of the bill is to penalize immigration fraud in connection with permanent partnerships. So that is integrated and central to your bill.
Thank you very much.